This appeal against what is a full bench Supreme Court judgment given by 5 judges, a reasoned judgment that was suspended summarily by this larger bench assembled in appeal after the Practice and Procedure Act, has taken so long that both sides, both those that felt that the initial judgment of the Supreme Court was one to be celebrated, which declared that military court trials of civilians are illegal, as well as those people who thought that the court had overstepped and this was liable to be overturned in appeal. Both sides are now able to point at the delays caused by the Supreme Court's inability to decide this appeal as being the main reason why, as being the main damage to this whole process. The government has been able to build up its case that it was going to decide, and the military tribunals were going to decide. Even if they were to decide to punish these individuals, their punishments would have run out by now, effectively telling the Supreme Court that these people are in jail because of you. Whilst that might not be true, the court could have remedied this situation by enlarging all of these people on bail and allowing for their trials to proceed, or not allowing for them to proceed, but taking the urgency out of the issue by giving them their liberty, because these are people who the Supreme Court has definitively said in the underlying judgment were being treated illegally. However, the court chose not to do this, ostensibly because it would have irked the powers that be, especially right now, and has instead taken the easier way out of letting these people be proceeded against and their trials to be concluded when the fate of that trial and its legality is before the court pending adjudication. It's what perhaps can be considered a way out, but a much cleaner and more appropriate way out would be to let these individuals out on bail and then to decide this appeal in whatever time the court thought that it would take.